I'm Alex Cleanthus. I work here at Gannon's in employment law and dispute resolution. I'm going to talk about wrongful dismissal and unfair dismissal because those are two concepts that often come up in the context of employment and dismissal, and people aren't always quite sure what they mean. Wrongful dismissal is when you're dismissed in breach of contract. Unfair dismissal is when you're dismissed in a way that the law says is unfair. And they work together, but they can be quite different. One of the main differences between wrongful dismissal and unfair dismissal is the qualifying time that you need to have been employed for before you can bring a claim. With wrongful dismissal, you have your rights immediately. They come under your contract of employment and you're protected from day one. For unfair dismissal, you have to have been employed for 2 years, or technically 2 years less a week in fact, in order to have unfair dismissal rights. There are also different remedies depending on whether you are wrongfully dismissed or unfairly dismissed, or perhaps both. Wrongful dismissal is a breach of contract, so your employer can dismiss you in accordance with your contract without it being a wrongful dismissal. In other words, really all they need to do is give you your notice. Either give you notice or usually pay you instead of notice, or payment in lieu of notice, pile-on as it's sometimes called, and that's all that it takes to avoid a wrongful dismissal claim. Unfair dismissal is a bit more complex. If you have unfair dismissal rights, your employer cannot dismiss you unless it's got a fair reason for a dismissal and it does so following a fair procedure. And fair reasons include things like capability or conduct or redundancy or a couple of other categories. For a wrongful dismissal claim, the maximum that you can claim is whatever is allowed under your contract. And you can bring that claim either in the ordinary courts, the county court or the high court, or in an employment tribunal, which will often be quicker and cheaper. However, you can only bring a claim for up to £25,000 in an employment tribunal for breach of contract. For unfair dismissal, if the tribunal decides that you've been unfairly dismissed, you would be entitled probably to what's called a basic award, which is a fairly small sum, which depends on your length of service and age. And also a compensatory award, and there's a maximum to that, which is at the moment about £76,000, or 1 year's salary, whichever is lower. So if, for example, you're paid £50,000 per annum as your salary, that would be the maximum of your compensatory award. If you're paid £100,000 per annum as salary, then your maximum compensatory award for the year 2014, most of it will be £76,574. What you can't do is have double recovery. You can't recover the same loss for both wrongful dismissal and unfair dismissal, although you'll often want to bring both claims together. And it can be quite a tactical decision as to whether you want to bring those claims in the employment tribunal or in court or in both, or maybe one after the other, which one first. And we can help in advising how to bring the claims and how to present them best in order to maximise your recovery. It's essential also to keep an eye on the time limits for bringing claims. For an unfair dismissal claim, the time limit is very short. It's 3 months from the date of the termination of your employment. That's 3 months counting the day in which you were dismissed. So if you were dismissed, for example, on the 13th of June, you would then have until the 12th of September to bring a claim. If you're bringing a claim in court, for wrongful dismissal, breach of contract, you actually have 6 years to bring a claim. So it can be a much longer time, and you can bring a claim, for example, for unpaid notice in court, even if your time in the employment tribunal has run out. Breach of contract claims in particular, wrongful dismissal claims, can be quite significant. They can include not only ordinary notice, but for example with a fixed term contract, they could include payment for the whole of that term. They can include bonus payments, commission payments, and sometimes these sums can add up quite significantly, and they can become quite large claims which are often brought in the civil courts, either the High Court or the County Court, depending on the amount. One term that you may have heard in connection with dismissals is constructive dismissal, and let me just explain what that is. Wrongful dismissal and unfair dismissal are when the dismissal itself is in breach of contract or unfair. Constructive dismissal is about how the dismissal occurs. Usually, an employee, you get dismissed. The employer calls you in and you have an Alan Sugar moment, you're fired. And that's a very clear dismissal. However, sometimes you want to quit. The employer behaves in such a way that it's completely incompatible with the employer-employee relationship and you're entitled to walk out. And that's called a constructive dismissal. The employer hasn't actually dismissed you, but you're entitled to say, right, that's it, I've had enough, I'm off, and it counts as a dismissal. And then you can bring a wrongful dismissal or an unfair dismissal claim. Constructive dismissal is very complex and very much depends on the facts, and it's essential, if you think you might have been constructively dismissed, to act quickly. If you think your employer has behaved in such a way that you might be constructively dismissed, for example, they haven't paid you or they've acted in a very offensive manner, something like that, it's essential you take advice very quickly to see whether you might have a constructive dismissal claim. We can help and advise on all these issues and anything else related to your employment, whether you've already been dismissed or if you think it's likely that you might be dismissed. Do give us a call or send us an email, and I'm sure we can help.